Asanteni Sana, thank you for listening in. And of course, this morning we are talking about sexual harassment in the legal profession. And of course, sexual harassment in law is no longer an open secret, as it says. The Law Society of Kenya has confirmed receiving multiple complaints, many involving senior advocates and junior lawyers where power and career are abused. Now, most cases never reach disciplinary action. The advocates are here. They will correct me if I'm wrong. Fear, silence, and influence stand in the way. With us this morning are two advocates, including one from FIDA. We have Betsy Ayanzwa. She's an advocate of the High Court, and Duncan Osoro as well, who is equally an advocate of the High Court. We are here to get some clarity on this. Good morning.
Good morning.
Oh, your mic was off, Betsy. Good morning.
Good morning.
How are you doing?
Doing well.
Hi, Duncan. How are you?
I'm good.
Karibu sana.
Asante.
I think we have all seen, there's a video that's been circulating on social media by one of your colleagues by the name Fee, yes. Right? Yes. Let me just play the clip and we'll talk about this.
You guys have just woken up and I feel like I'm so mad. I'm so mad at LSK. Imagine, as the professional body that was meant to protect the welfare and interest of the members, I think you have really failed. You have failed, because the reason why I'm so mad is that a case was filed at LSK, I think it is last year, right, about this specific case of sexual harassment. Nothing was done. Hata hu kijana hakuweka defense. Nothing was done. And then some of the members of LSK wanakuja kwa page yangu wanakuwa surprised. Why are you surprised? What is LSK doing? Let's leave even minimum wage kando. Is sexual harassment something to joke about? Like, and you're just hanging around with that vixen. You guys mnajua mimi ni mtu wa kanisa na ndo nimeamuka saa hii because of these messages, these screenshots ambazo nimepata. What is LSK doing? Is there hata kuna hiyo sexual harassment policy kweli? Is there a legal committee that can handle this nini kama ADT? Because we need solutions. Imagine seniors can't be taking advantage of female young advocates because they are desperate of work. We can't continue like this. Farms are something else. We are protecting people. We are fighting for people, but our rights are in the pits. You guys. I'm so mad. Kwanza mambo na sexual harassment. I've been a victim and I can know what it does to people. So this is not something to joke about. Baby, this is not something to joke about. I'm not here to joke. I'm here to call out LSK. I need to know your stand. What have you done on these issues? Alafu, you are doubting. Thousands, 10 people can lie. Thousands of messages. People have sent me screenshots. Alafu mnasema ni uongo. Kwani who is this guy? Okay, that guy alone. His sexual harassment. There's so much disturbing. You guys, we need to do something. Ata kama ni maandamano, we need to do something.
I think we've had it. That is Phoebe Wandera. She's an advocate as well. And of course, she's calling out a lot of things in the profession. And one of the things that she's saying is that what is LSK doing when it comes to sexual harassment? Duncan, and I want to begin with Duncan. Is there sexual harassment within the legal profession?
That one cannot be denied. Yes. Given the complaints that have come forward.
Yeah.
The only problem we have, yes, even we also to cure that, the LSK came up with a policy, sexual harassment and anti-bullying policy. And once these complaints have been received by the LSK, they are channeled to the Advocates Disciplinary Tribunal.
Mm-hmm.
The only problem is that the tribunal has no mandate to prosecute criminal offenses. Of course, we know sexual harassment is a criminal offense under the Sexual Offences Act.
Mm-hmm.
What the ADT can do, that's the Advocates Disciplinary Tribunal can do,
yes,
is just to disbar you, take away your certificate, your license, so that you don't practice. But then, what is the remedy to the victim? That's the lacuna we have. The victim has no remedy. It does not tell us how the victim can be compensated, because sexual harassment goes into your mental health, psychological. Someone cannot operate because you have been forced, even if you are, in some instances, sexual harassment occurs in environments where you cannot disengage yourself from, maybe because of the consequences that may arise or fall from there. That's the only problem we have with the LSK policy or the tribunal that is mandated to act on this vice.
Yeah. Betsy, Fee is talking about our rights are in the pits. She's saying our rights are in the pits, and you've listened to that. First of all, what do we make of her comments?
Thank you. From the very onset, what she speaks about on sexual harassment, I would quickly go to the Sexual Offences Act and Section 23(1 that actually tells us what is sexual harassment, where it defines it as persistent and unwelcome sexual advances, typically made by a person who is in authority or by a public officer. And they are made, when it now comes to the work environment, they are made in exchange for either an opportunity, advancement, and the advancement could be either the job itself or advancement in terms of financially, what is your remuneration, whatever that you receive. Therefore, it is used as a tool against a person. It is persistent. Keynote, it is persistent and it is unwelcome. And that's where we hear the word that no is a complete sentence. Probably as my senior has stated, that does LSK have a policy? Yes, it does. A robust policy that was set up in the year 2019, and it was endorsed by members, remembering that LSK is a member-led society. So the members have endorsed a policy. But now the question that arises is the policy sufficient enough, especially to address the issues that have been brought up currently? And probably that's where our challenge arises. Also noting, as Sini has also alluded to, that sexual harassment is not just a civil matter, it's also a criminal matter. And therefore, it also behoves the person who is making the claim or the allegation that have the matter reported to the relevant authorities, in this case, to a police station, because investigations need to be conducted to ascertain the nature, because sexual harassment comes in various forms. It could be messages that I send him, photos that I send him that are suggestive, inappropriate touches, various communications between parties that one party is they are unwelcome to one party, but from the other end they are persistent, and you fail to understand that these are persistent. So when it comes to, at the end of the day, do we have a policy? Yes. Does it sufficiently address?
No.
Now that's where it comes back to us as members, and we need to review our policy.
Why does the legal profession, of all places, that defend justice struggle to protect its own? Does it struggle to protect its own?
I would say yes and also no, because by virtue of the fact that we have a policy, it acknowledges that yes, there is need. There is need. This is something that it is a society, it's a community with people. And where you have people, you do expect conflict to arise. Or where you have people, you do expect deviances. They most probably will arise and will occur. Has LSK failed as a society to protect its members? I would say maybe there's a certain percentage probably in terms of effecting it, because we have the Advocates Complaint Commission, that is ACC, and we also have the Advocates Disciplinary Tribunal. We have a tribunal, and the members of the tribunal are actually elected by we the members, except the head of the tribunal. Therefore, as a society, have we seen this need? Yes. Have we tried to address the issue? Yes. Probably we need to put better mechanisms to be able to better serve or to be able to better attend to the needs as they continue to arise in the society.
Yeah. Duncan, walk me through, when a young advocate faces sexual harassment, what's the procedure? What should they do?
First, they should do a formal complaint to the LSK. The only problem is that at times they do not know the members of this committee or tribunal. So it's sent to the secretariat. Therein then, now the complaint is forwarded to the relevant committee or tribunal then. The alleged perpetrator is informed of a complaint against him or her. And then now he's supposed to put in her defense or his defense as to why he's innocent. The only problem now arises, as you said from the first time. Once that defense has been put in, they just listen to you. They listen to both parties. Because we are advocates, we say Article 50, fair hearing, we have to hear both parties. So it's not automatic that once I have reported you, you'll be punished. It's not. The problem comes when now at the conclusion of this investigation or hearing, it's either you are told you are not guilty, so you continue with your practice, or you are disbarred. Now, this again depends on the evidence standard. How is this junior going to give evidence or prove that I really touched her? No video recording. Does she have evidence?
What kind of evidence should one present actually?
That's the problem now when it comes to, because now we are not told that it's a criminal court where the threshold is beyond reasonable doubt. It's on a balance of probabilities.
When you say it's on a balance of probabilities, Betsy, you broke down what sexual harassment looks like, right?
Yes, before you go to Betty now, I'm
Go
talking
ahead,
about
yes.
the tribunal itself, not the court, not the judicial system itself, not the court. Under the Sexual Offence Act, where it should be reported to the police,
Yes.
investigations conducted, and then the files goes to the DPP. They either decide to charge or not. This is a tribunal where Betsy has brought in a complaint against Osoro. Then Osoro is summoned. Osoro also has to give his written reply, how they met, what has been going on in the office or wherever they have been doing, what has her character or habit, or how close have we been, in that one can confuse to be sexual harassment or it is actual sexual harassment. Now then it's upon the committee or the tribunal to give its verdict. As simple as it goes.
That's very vague,
Eco.
right?
Maybe what I can also add to what Senior has spoken about.
Yeah.
The Employment Act of Kenya has a requirement under Section 6 that in any organization that has more than 20 employees, there must be a sexual harassment policy in place. And the sexual harassment policy, it defines what sexual harassment is, who is the complainant, the nature of the complaint, and critically, what are the steps that you need to take to address a grievance. And so, if, as much as we're speaking about it in the legal space, it is applicable all across. We also appreciate that we have many firms that don't have a staff composition of 20 persons. Therefore, even as a firm, you need to have in place a grievance mechanism that once an employee has a complaint, there is a process that they can follow, because before they reach the ADT, what at the firm level, what has been done. Also, like he says, when we speak about sexual offenses as a criminal offense, there is something in law that we call the burden of proof. The burden of proof rests on the complainant or the accuser or the victim in this place. That even as he said that I go and lodge a complaint against him, what do I have? I'll give you a classic example. There was a petition that was filed in the Employment Labor Relations Court in Nairobi sometime in 2022. The judgment came out in 2025. A citation of the matter is, I think it's Angawa versus Kituo cha Sheria and another, in which the claimant was dismissed from her place of work on allegations of sexual harassment. The court determined that the actions of the complainant actually condoned. The issue that was arising was that this particular employee, who was a supervisor, and interestingly again, it's legal related, lawyers, that there are names that she was making reference to her colleague. There was baby boy, lollipop.
I remember that story. Yes,
something to that.
Yes,
effect.
I remember that. Yes,
and the complaint was made, and this lady was terminated. But when the matter went to court, the court held that for a year and a half, these comments kept on being made over and over and over, and the complainant did not complain. That's why I kept on saying it is persistent and it is unwelcome. There needs to have been a demonstration that it was unwelcome.
Okay, so if I were to say, I keep calling Salim baby boy,
Yes.
lollipop, right?
Another one.
And
Yeah, me, I'm not going to file a complaint.
if I keep on doing that and he's receptive to it, then I cannot go back and say, he cannot go back and say Miriam sexually harassed me,
That is correct.
because
As
he's been
established.
receptive to it.
As
He's not
established
shown
in
that.
judgment.
He's not shown that I'm making him uncomfortable.
Yes. So long as he condones it. And this particular case, the judge went ahead, I think based on evidence that was tendered. There was even, I think, a birthday that was celebrated. And on the cake, it was written baby boy. And I think they went ahead and celebrated. And so the court said, you condoned it. There was actually, and that's why it needs that definition of persistent and unwelcome.
But now, when we come to matters, when it comes to power, right? We are talking about senior counsels here, and we're talking about young advocates. I'm just getting into the profession.
Yes.
Okay? There's an element of me getting into this. And then power play is, this is somebody who's probably the position is higher and all that. And when they make certain advances, at times it can be subtle, right? Do we see an element of fear amongst these young advocates when so let's say if it's Duncan, and so Duncan could be making advances, and I'm thinking, how do I go about reporting Duncan's advances without hurting my career? Is that one of the reasons why it's like we see hush tones within the corridors of justice?
You see, there's what they call is it a career-ending moment. Let me start that. The only unfortunate thing about the young advocates or the interns who are coming to the law firms.
Yes.
It is a policy that once you are out of the Kenya School of Law, you must undergo what we call pupillage, and that must be under a senior of about 5 years standing. Many young advocates struggle to secure these places in law firms. They are desperate. Without that, you will not qualify as an advocate. You will not even be admitted. Now we come to another word called untouchable senior. The person in authority. It comes that even if you have been sexually harassed, the person you are supposed to report to, the person who is supposed to protect you, is the one or is the main perpetrator. And is the one holding or tangling that carrot. You don't do it, I don't sign that book.
Okay.
You understand?
I get you.
So we come to what we call now, is it structural imbalance. As this junior who has been harassed, where else is he going to?
Yeah.
Who is he going to report to?
Why you said
Yes, the problem is the fear of reporting.
Yes.
Here is my senior who is supposed to sign my book. He has told me to Naivasha hii weekend. I'm like, hapana. Unajua kitabu yako sasa utasainia wapi? Nilikuwa kwenda kuuliza maswali fulani.
Gani?
This is what we call a workbook, pupillage workbook.
Yes, no, sorry, I'm playing along.
Oh, you are playing along.
Yes.
How? Because I've been sending you to errands, I've been sending you to court, so I want to know, when you are writing this report, what did you learn? Because I have to put in my recommendation down. Like,
yes.
If you are duly qualified, you understood the process.
Yes.
Then some of them find themselves tagging along. The more bold ones will say, no, I resign. They will write to the Kenya School of Law, I'm not comfortable with this law firm. This is what's going on. Please release me from this. Let me find another pupil master. Those are the few bold ones.
Yeah.
But here come to what, in quotes, the weaklings. This is my destiny. My career depends on him or her. See, I'm using the word him because major all the surveys is that most female advocates are the ones who are undergoing sexual harassment. Yeah. We are not talking about the men, though there have been instances where men bold enough have come out, because in Africa we say a man bwana ukiambiwa mwanamke amekukatia hiyo ni advantage, nyamaza.
Hiyo ni through ball.
Kanyagia sio.
Chutulia.
But that's some mimi sikupendi. But I'm at your mercy. You understand?
Yeah.
That's the lacuna we have in our policies, save for where it has been expressly provided that it is a criminal offense. And the only remedy we have in Kenya is the Sexual Offences Act. The Employment Act, as my colleague said,
Yes.
that's Section 6. Even if you are 20 or more employees and they have a policy there,
Yeah.
remember, under the Employment Act, you are not going to terminate any employment just because you've been told. There's a procedure to terminate that person, the perpetrator. And this person you want to terminate is the HR or the head of the legal department. He says, I know the law, let's go. The only remedy we have is that LSK, now that we are talking about this vice in the legal corridors,
Yes.
either from the top tier law firms to what we call OB. OB is a Onyalo Biro in Jaluo. The OB law firms in easy the briefcase wanatupata in one room where atakwenda kutafuta mahali pa kwenda kutusaidia, lazima ende nje akanjo unue. Hiyo ndio Onyalo Biro.
We've learned something.
We are talking about this. We are talking about in the legal corridors.
Yes.
Then, as members of LSK, we must align our policy with the provisions of the Sexual Offences Act.
Correct.
So that now we can have meaningful discussions or remedies to this vice called sexual harassment.
Okay.
As my colleague said, or as it has been defined in the Black's Law Dictionary, sexual harassment is direct or indirect sexual advances. You know, this includes the lewd words msupo, vipi msupa. Napenda hiyo nyashi. Sexual harassment. Touching. Hii mnakimbia hapa, unamshika hapa shoulder.
Yes.
But why?
Why?
That's sexual harassment.
Yeah. Yes.
Hata hapa najua mko na legal department. Yes. We are talking about the legal corridors, not only law firms.
Yeah.
Sometimes we will go even to the court itself. These things happen there. Then it is to align our policies. In fact, I even suggest that all other organizations in their HR policy, they must include sexual harassment. And what happens in that instance.
All right.
I'm gonna go back to first the definition that you gave of sexual harassment. Okay. Persistent and unwelcome sexual acts towards someone. Yes. Now you've gone further and explained it to be either direct or indirect. And then now you've gone forward and you've shared the different acts that someone can do. But you also say that the burden of proof rests on the complainant. Yes. You understand? So this is me thinking I want to put myself in a situation whereby I am either touched inappropriately or called in an inappropriate manner, and it has happened for the first time. See, it has happened for the first time and I don't agree with it. But for me to take action upon it, number one, the definition says that it's persistent.
Correct.
So ideally, this happening at the first time means I should be able to shut it down for it to never happen to me again. First.
Correct.
Number 1. Number 2, without me having any proof whatsoever that you've done this to me, nikiipeleka mbele naonekana kama mtiaji. Sindio? I naturally. I'm not talking about procedure wise. I'm talking about nitaenda nikuseme, but sasa wewe ni boss wangu na unaona nimekusema utasema wewe mse ako chini. Number 3, we have realized that there's a gap in how guys can make these complaints. Someone will make a complaint, it will go to the ACC, and then it will be directed to the ADT. And even when you're not able to, whether or not you're able to provide sufficient evidence to prove this claim, they will either, what they can do the most is take your license away. But nothing is going, no compensation, nothing whatsoever is going to be done to the complainant. So there's already another gap there. I'm not just asking for myself, but I'm asking for other young people. Is it safe to want to be a lawyer? And now when we are tied down to definitions, when you say that the definition stays to be persistent and unwelcome, like does it mean that I'm going to continue feeling unsafe to reach a certain career level? I cannot openly communicate these things. And of course, majority of the complaints that we get are usually from ladies. Yeah. But continuously, they're the ones who feel more and more unsafe. So procedure is there. Procedure for young people, law looks like a lot of words, but there's no action. There's no safety in what you guys have told me. In short, you told me that it can continue happening to me on days on end, and only action will be taken if I not only just tell you guys, I also have to go and tell the police. I also have to record these things. I also have to install CCTV.
So the question is it safe? Is it safe to be in the legal profession? Is
and
it for a young person?
Safe?
Extra safe.
Yes.
Extra safe.
Yeah.
Yes.
It's only that realize yourself. You wake up. In the new dispensation of the new Kenya that was created by the Constitution of Kenya 2010, Chapter 4, very elaborate, caught in very simple English. Once you realize your rights have been violated, in fact, we have also some regulations or rules, the Mutunga rules, which gives you the format or formula or how to approach court.
Yeah.
Once your rights are being violated, or when you think you are being violated. When my colleague said it's persistent and unwelcome, the first time, maybe you are in the same office with our colleague here, you've been making jokes. So she thinks the jokes are okay with you. So it's upon you to say, hey, madam, boundaries, please.
Boundaries.
And if it is persistent, means it does not happen only once. You have your colleague here. Mazee ambia nania wachana maneno. Sitaki. You see, now you have even a witness. So it's not a standalone thing that it has been persistent and then you've been living on an island, only two of you. Yeah? At least get out of that space. I gave an example where a young advocate can terminate the pupillage period in that firm and go to another firm where she or he feels is appreciated and respected.
Okay, mimi niko na mashaka hapa. Hii kitu huyu wakili mwingine ni Phoebe ama ni Phoebe amekuja nayo, ni kumaanisha kuna vitu vingi chini ya maji huko vimekuwa vikifanyika na havichukuliwi hatua. Ni kumaanisha kama LSK in the corridors of law wenye nyinyi mawakili mnaiweka, ni kwamba vinafanyika lakini vinawekwa, Miriam unasema chini ya carpet. Kwa lugha ya mtaani tunasema chini ya maji. So huyu ako agitated ya kwamba kitu kinafanyika na utuchukulie ni wewe senior because amekuwa address kama senior, wewe ni senior na unajulikana na vitu unafanya, lakini hakuna kitu ambacho kwamba kinafanywa. Kuna tukio lolote moja, nikianza na wewe senior, ambalo liko la mfano limeonekana kwamba huyu amechukuliwa hatua mpaka akafikishwa na mpaka akafungwa kutokamana na hivi vitu ambavyo kwamba vinatokea, hizo harassment na kila kitu, before nije kwa huyu ambaye pia yuko kwa FIDA?
Only that I cannot remember the parties. This is a matter that the ADT said we have no jurisdiction to prosecute or determine sexual harassment because it falls under the criminal justice system.
Okay.
Unaelewa? So ametupa victim wapi ama the complainant wapi? Toka nje, nenda further the legal way, or right the right procedures, the right authorities to prosecute this matter. Only that I don't know where it went to.
Okay.
Understand? The others is what that now came up in our friends' wall. And that's why I say there is what we call fear of reporting or retaliation.
Okay.
Others will say, this was a willing buyer, willing seller. Because ulikubali kwenda Naivasha, mkafanya vile mlifanya, mkarudi. Though haikuwa kwa kupenda kwako, but circumstances forced you into that. Then where do you put this? We call them a survivor. We don't call them victims. We call them, where do you put this survivor?
Okay. Betsy. Kwako.
Thank you. Number one, the disciplinary tribunal, it's confidential. Si rahisi kuweza kujua all complaints that have been forwarded to the disciplinary tribunal and the outcome, because in most instances they would be confidential matters. That is number one. Number two, like he said, an example being, I don't know if we remember, sometime last year there was a complaint against a certain teacher from Alliance High School.
Okay.
That was made by students, even former students. What helped the school determine that matter is many came out and said, even me, this happened, even me, he did this, even to me, he did that, even to me, and you can even quote specific dates. I was in his house between this duration and this duration. On our end, like he says, it could be the fear of reprisal, the fear of the repercussions. And remember, we are a society. We are colleagues. Such that if I report Salim, and we're in the profession, and Salim goes and tells his cronies, my concern is, as a young advocate, what happens to my career? And therefore you find that many do not come forward. There was a matter that was actually cited by our president in her communication yesterday, where there were 22 complaints raised against a specific party. Of the 22, only one came forward to tender any evidence against this particular party. Therefore, it becomes, is it malice? Is it genuine? And really, because the parties or the complainants could genuinely be fearing the outcome of this entire process. What if I end up being blacklisted? And that is why, as a society, we must collaborate. I will say we must collaborate even with organizations like FIDA, whereby if we look at it on the part of the survivor, sometimes it needs psychosocial support, that Salim is taken through counseling, and with counseling he's able to overcome that fear and actually say, yes, it happened to me, that yes, it happened to me in 1, 2, 3, 4, 5, and an assurance that because I came forward, it will not be used against me.
And I think, but I think that's a question. How sure am I that a senior counsel who is well connected would actually be held to account? Yes, I'll come and report, right?
Yes.
I'll come and report. Osoro has said that you can terminate your pupillage, right? But not so many people come up to terminate the pupillage.
Yes.
You're at the beginning of your career, right?
Yes.
And so I know the person who's sexually harassing me is a senior counsel, right? And maybe this person is also well connected. it's me against him, and it's not just me against him, it's me against him and the system. How safe am I, again, when it comes to reporting this matter? How safe are these young advocates?
You are safe.
Yeah.
I would say, as a young advocate, you are safe.
Yeah.
By virtue of the fact that we have a policy, number one. Number two, we have members of this tribunal are actually members of the same profession. We are colleagues. And one thing, even upon our admission, we take an oath to uphold integrity, to uphold the rule of law. We actually oath on that. And I would want to believe that as I took the oath, as senior took the oath, as we all took the oath, we would be able to be faithful, loyal, and true to that oath.
Okay.
Number one. Number two, as has been stated, there are various avenues of addressing sexual harassment. Various avenues. We have various players in the field, whereby if I see that from ADT I'm not getting the kind of support I need, we have FIDA. If at FIDA I'm not getting the kind of support I need, we have, it is being a criminal offense, report it to the police. The police have an oversight, that is IPOA. There are many steps that can be taken to be able to address the issue. Maybe it might come with an element probably of exhaustion along the way, because it might be seen to be. But even now, as you are speaking, I know, having these issues raised, we will become more diligent. And we need many more voices to speak up, and that way it makes us more accountable to ourselves and also to the members of the society.
Kwa sababu tumetaja uoga hapa, hiyo mnaita fearism.
Yes.
Fear.
Fear, yeah, that
Kuna
one.
fearism.
I don't know the legal language.
Yeah.
Wakili Duncan
Yes,
Osoro.
yes.
I love the other name Osoro. Ili kwa sababu mko na policy ziko tayari.
Yes.
Lakini kuondoa ule uoga wa mtu kutaka kufika mbele ni in your own capacity. Now hii ni opinion yako, not what you have as the policy. Ni vitu gani ambavyo kwamba vinaweza vikaongezwa kwenye hiyo policy ambayo kwamba iko iniwezeshe mimi the young practicing lawyer niweze kuwa na nguvu ya kuja forward na kuweka malalamishi yangu?
Yeah, because I remember he said there's the fear of reporting.
Yes.
Because maybe you fear retaliation, exposure to your colleagues, kwamba huyu dokimwongelesha atageuza mambo vile anataka. Mimi kwa maoni yangu is we incorporate other legal provisions or acts that protect the witness or the victim. In Kenya we have what we call the Victim Protection Act.
Yes.
We have the Witness Protection Act. Yes. If we can align or tweak our policy so that it includes the provisions of these two acts to protect the victim, that before we disclose the member, maybe then we can even involve investigation authorities to investigate and go to the core of this matter. Under the Victim Protection Act, you can protected, your names cannot be exposed.
Yeah.
Then now again you can have a legal counsel for the victims representing you. Witness Protection Act, unaweza fichwa mali unafichwa, lakini unaweza toa testimony yako in camera. Now these are some of the areas that are lacking in our policy, not unless
That is correct.
those are some of the areas that are lacking in our policy. Si tulirushiwa tu policy hapo tukajua tumelindwa ama wenzetu wamelindwa, because at one time even these seniors were juniors.
Correct.
Yeah.
Yeah, and maybe some of these things they're doing to the young advocates is what happened to them. Sasa tukasema we have a policy, we can fight for ourselves, only to find that there is a very huge lacuna in there that cannot remedy or cure the wrongs that are happening. That's why even those who were giving those testimonies, those who are writing, they were writing under anonymous names.
Yes.
They were not coming out, but they were only naming the perpetrators.
Perpetrators, yes.
That's what that's why FEE is calling it a safe space. because now they found somewhere to hide
Yes.
and talk.
Yeah.
As opposed to writing, because now when you write, you have to put in your name there, your letterhead, you send to LSK. And the perpetrator will come and say, I want to know my accuser. Who is the accuser? Who is the complainant? Because do you know why he's doing that?
Yeah.
They have called you and told you, wewe umeshtakiwa na hii na hii na hii na hii.
Yes.
Have they investigated? No. Have they called for enough evidence? No. Do we have a database for these allegations or victims or alleged perpetrators?
No.
I think it's just a file. I've not been that tribunal, but I think it's just a file. Then why can't we have a database where if you receive about 10, 20 complaints on Duncan Osoro, sincerely, all these 20 cannot gang up against me. Right?
True.
Then, as I said, I will go back answering your question is, we must incorporate other laws that talk on sexual harassment, or what I can call in a wider description, one of the offenses under the sexual gender-based violence offenses.
Sorry, you've talked about you've brought an interesting perspective. When this so the names have been mentioned, right?
Of the perpetrators.
Yes, of the perpetrators, and from Phoebe's platform, right? And those who are reporting are anonymous, right? The names have not been mentioned. Now, is there possibility that just by the virtue that I've mentioned your name, that now action can be taken? Or, again, like you've said, I have to write a statement and I have to put my name on it, right? So meaning even right now with the mentions of these perpetrators, nothing much can be done? Is that what we're saying? Are we still in a case of an allegation? It's not factual.
It is purely an allegation.
Yes.
Okay.
And to add on to that, we have Article 50 of our Constitution, where everybody has a right to a fair hearing. So if you are to mention me adversely, you need to provide me with the information as to what it is I'm being accused of and who is my accuser, very critically. Beyond that, it actually rests on allegations.
So something controversial, since these names have been mentioned on the lady's page, right? And she's mentioned, let's say she's mentioned Osoro, she's mentioned Betsy and another person. What is she liable to?
At the end of the day, being the person actually publishing, because reputations here are being touched. People who are in practice, and remember, when we speak about a senior, is somebody who's been in practice for over 10 years, and probably their name has never come up in the disciplinary tribunal. There has never been a complaint made against this person. Now, for anonymous messages being received, and then I choose to be the one to broadcast them. We are looking at tortious issues of there is libel, there is slander. So long as these anonymous complainants do not avail themselves and make formal complaints, again now burden rests with the owner of that page.
So we cannot say they are scared. We cannot say that, because Osoro has talked about witness protection, right?
Yes.
We cannot say they're scared for, they're protecting their career. They're scared to come out and say it's this particular senior counsel. Are we saying that investigation won't be launched into these allegations? Would there be any form of investigation?
You see, for any investigating body to launch or to commence investigations, there must be a formal complaint. There must be a formal complaint. Either they might want to do it undercover, and at the end of the day, they will have to call you as the accused to record your statement and or offer your testimony on whatever you know.
Yeah.
As we started, we said this person is going to ask, who is my accuser?
My accuser.
Because I have dealt with them more than 30 people. Does it mean I've touched all of them? Have I arrested all of them? Who is this guy that is accusing me? That's why when she started, she said about Article 50, one of the tenets of natural justice, simply says, hear the other party. I'm not going to kill you just because I received information. I have to give you an opportunity to explain yourself. Now, then, if there are going to be investigations, then the main witness is the one of that page. Because now she knows the people who posted.
Correct.
Okay. Osoro, I'll take you back to something you mentioned, that there are untouchable seniors.
Yes.
Who are these people?
In quotes, I say in quotes, untouchable seniors are the people that you are directly answerable to.
Why untouchable?
It is untouchable in quotes because now this is the person you are supposed to report to. Either is the HR or is the managing partner. But now again, he is the perpetrator. Where else are you going to? Now, it makes the victim timid. He fears. Nikimkataza, I face the exit door.
So if my untouchable is the one who is sexually harassing me, you've also said that I can terminate my pupillage and write to the Kenya School of Law and say that I be moved to another law firm. Now, wouldn't I also be asked to put down reasons as to why I'm asking to move from this law firm to the next law firm?
Typically, no. So long as you present your request to Kenya School of Law and wish to change your pupil master, it's granted. Because it means you start your pupillage again. Remember, it's part of the process towards your admission. It takes 6 months. So if you have decided halfway along the journey, you're changing your pupil master for one reason or another, you will start the journey afresh.
Are we saying these untouchables or these senior councils?
Yes.
Are we
The untouchable
saying?
is in quotes. It's not. They are not untouchable
Okay.
to the law. They are not untouchable to other authorities.
Are
They
we
are untouchable to you.
To me,
The
because I
victim.
report to them.
Yes.
But I'm also seeing an element of the system. It's like the system is not really set up in a way to protect the victims. It's not really set up in a way to protect the victims. And I think,
Complaints for the reason to move, then nothing is going to be done to address that. If I want to move a law firm because I'm going through a certain thing, and for me to put in the request to move, I cannot explain why I'm moving. Then whatever is making me move is going to make other people move when they come. And because no one is taking note of whatever is happening here, then there's nothing happening. It continues to happen and becomes a culture.
I hear you. Remember, if you are lodging a formal complaint, especially if it is based on sexual harassment, remember there's the element of investigation. An investigation has to be done. You have to tender whatever evidence you have against this person. Remember, this person has right of response. They have to come and reply, and then the outcome. Question becomes the duration vis-a-vis how long do you want that program to take? I hear you, and it is a very genuine concern. Probably it ought to be, and I hear what you're saying, it is an area that also could be able to address issues of harassment and nip it in the bud very early, while someone is still a pupil. Vis-a-vis, you continue on, you become an advocate, and this practice continues. Probably that is food for thought, that we can always be able to take back to ourselves, be able to internalize. And also on the same aspect, it also calls for us as a society, probably we need to have a separate organ of non-advocates who will probably be the ones to handle this nature of grievances.
Like IPOA investigating the
May
police.
not necessarily be IPOA. Maybe that we'll have in it psychosocial support, people trained in investigation, because also at the end of the day, ADT or the tribunal is composed of advocates. You're calling advocates to also investigate
Their fellow advocates. Okay.
ngumu sana.
This is a conversation that definitely will still continue. It's there's a lot that's coming out of this, and I'm hoping that we'll get to a space where the young advocates come out and speak freely. And I think what's coming out is you have to record that statement. Yes, and you have to come out in numbers, right? Yes. And I think we're in that era where come out, speak up in numbers, record, and bring things out in the light.
To sanity.
We've been speaking to Betsy Ayanzwa. She's an advocate of the High Court and a member of FID as well, and Duncan Osoro, who's equally an advocate of the High Court. Thank you so much for joining us today.
Thank you too. Thank
we
you.
will be right